80% of the population practicing agriculture.
Green tea is different from black tea. Green tea does not go through the fermentation process of the factory, meaning that it has retained all the medicinal values in it.
This is a good leaf for plucking.
When it is already marked, so like it has the marks, it is very easy for a farmer to just follow those markings and then drop.
Join us every Wednesday as we showcase comprehended and well-researched episodes on agriculture, on the new innovations, planting, harvesting, modern technologies and more you would like to know in the farming field.
The farmers, they no longer bring more of comb honey.
So after extracting the honey from the frames, then they are removed and placed back in a super.
Farm Matters, a program where all your farming needs are addressed.
Kyagulanyi loses interest in the presidential petition as Museveni's lawyers say are not surprised. A very warm welcome to you tuned in to UBC TV to our news tonight, this Monday, the 22nd of February 2021. My name is Micheal Jordan Lukomwa. In a first story, former presidential candidate Robert Kyagulanyi Ssentamu has withdrawn his presidential elections petition filed in the Supreme Court. According to Kyagulanyi, he sees no fair dispensation of justice to prevail in the matter before the court, following the court's refusal to admit his 200 affidavits presented last week. We have details to this.
On 1st February 2021, the former presidential candidate Robert Kyagulanyi Ssentamu filed a presidential elections petition challenging President Yoweri Kaguta Museveni's victory in the 2021 presidential elections. Although Supreme Court justices directed and ordered all parties in the matter on the way to go in filing their submissions, unfortunately the petitioner Robert Kyagulanyi Ssentamu defied these orders when he filed his evidence after 14th February 2021. Contrary to what was directed. Following this, last week, Robert Kyagulanyi's legal team, led by counsel Mary Anthony, filed an application in Supreme Court seeking court leave to file the remaining 200 affidavits in support of his case. However, in the last court session before the panel of 9 justices of the Supreme Court, led by Chief Justice Alfonso Munyidolo, court declined to admit Robert Kyagulanyi's application.
By a majority of 8 to 1, this court disallows this application.
Following this, Monday morning, the former presidential candidate Robert Kyagulanyi Ssentamu vowed to withdraw his application from the Supreme Court. According to Kyagulanyi, since his affidavits were dismissed by the Honorable Court, there seems no justice to him from court.
And I've just told you that more than 200 of our pieces of evidence have been rejected. Among those were some from our fellow opposition members. Was an affidavit by our Secretary General, was an affidavit by a comrade called Kalundi Serumaga. So for that matter, ladies and gentlemen, for the reasons that we've given above, we have decided to withdraw from their court.
Kyagulanyi, who is yet to instruct his legal team to take action, adds that they don't opt for any kind of violence in taking any decision outside courts of law.
We are not violent people. We are withdrawing from the court, but we are not opting for violence. We are going to the court of public opinion. We are going to the court of the people of Uganda. We have therefore instructed our lawyers to withdraw the case from Mr. Owinyidoro's court.
In filing this petition, Robert Kyagulanyi Ssentamu was opposing President Yoweri Museveni's victory, the Attorney General and the Electoral Commission. Last Saturday, the respondents in this matter filed their responses, maintaining the status quo that Robert Kyagulanyi Ssentamu was contrary to the laws governing legal proceedings, submissions and time limits. However, on this, the petitioner, Robert Kyagulanyi Ssentamu, says is ready to all the would-be repercussions in this matter.
I want to tell them in no unequivocal terms that we are not scared. The price that has already been paid is too huge.
It was during the same presser that Robert Kyagulanyi Ssentamu condemned UPDF officers who beat journalists at the UN offices when he had gone to petition the United Nations Human Rights Commission ongoing human rights violations in the country. Robert Kyagulanyi Ssentamu communicated this during a presser at the National Unity Platform offices in Kamocha. Deborah Namamonde, Robert Onyango, UBC News.
Relatedly, on the same item, a lawyer in the same case, the presidential election petition that had been lodged by the National Unity Platform presidential candidate Robert Kyagulanyi against Yoweri Museveni's victory, says he's not surprised by the planned withdrawal of the petitioner. Counsel Hussein Kashilinji says that the case lacked a legal basis and was more of a joke. That is according to him, as we hear in this report.
If I may introduce.
According to the Presidential Election Petition Act, Section 61, an election petition shall not be withdrawn except with the leave of court. This means that Kyagulanyi's announcement to the media to withdraw his petition challenging President Museveni's victory of January 14th will only be valid after the same courts grant him the request. But even if the courts accept Bobby's petition withdrawal, this may come with costs, as President Museveni's lawyers are planning to demand for compensation.
Once the courts have heard the application and accepted it, then the case is withdrawn. Once it is withdrawn, then there is no petition pending before court. But what it also means is that now the lawyers for the respondents, there are 3 respondents in this petition: Yoweri Kaguta Museveni, whom we represent, there is the Electoral Commission, and then there is the Attorney General. So these respondents have incurred costs during the preparation of this petition. So we will go to court and ask that Honorable Kyagulanyi pays these costs. That is the implication on his part. He has to pay the court to meet the costs of the petition, whatever we have incurred.
According to the Museveni lawyers, Bobby Wine's petition lacked evidence and legal credibility and could be the reason he has decided to opt out of the petition.
My view is that this case was dead from the start. It was a weak case from the start. It was a fishing expedition, an amateur attempt actually at fishing. They filed, what happened is that they filed the petition and then they went and started looking for evidence. Yet usually when you're going to court, you have your case, you have your evidence, and then you file. But in this case, what we've witnessed is that Honorable Kyagulanyi never had the evidence. He filed the petition and then started looking around, shopping around for evidence.
Kashilingi further rubbishes Bobby's allegations of bias among the judges.
By the time Honorable Kyagulanyi decided to become a candidate in this election, those judges were already in the Supreme Court. Those judges were not appointed in anticipation of Honorable Kyagulanyi ever bringing a petition. Secondly, Honorable Kyagulanyi, at the time he filed this petition, he knew who the judges of the court were. It's not that there was a secret that they didn't know who was going to determine this petition. So he knew who the judges were, and he went to them. They did not come to him. It is him who chose to go to the court. The court did not go to him. So for him to start alleging bias on the part of the bar, on the judges, even before his petition is heard, is just indication that he just was not ready to prosecute his petition.
Philip Aguta, UBC News in Kampala.
Despite the withdrawal from the hearing and the case by the NUP presidential candidate Robert Chagulanyi, the judiciary says the presidential election petition is scheduled to resume on Wednesday, the 24th of February 2021, with all parties in the case expected for the hearing. According to the judiciary spokesperson Jameson Karemani, whereas the petitioner Robert Chagulanyi has announced plans to withdraw the case, court has to be formally notified and decide on the matter.
We are going to take this matter to the court of the people.
Since last week, on several occasions, National Unity Platform principal Robert Chagulanyi Sentamu has been insinuating on plans to withdraw the 1st February presidential petition from the Supreme Court. Monday, 22nd February 2021, has seen Robert Chagulanyi rubber stamp his long-day dream into reality.
For the reasons that we've given above, we have decided to withdraw from their court.
As per the provisions of the Presidential Elections Act as amended in 2005, Article 6.1, Clause 1, an election petition shall not be withdrawn except with leave of court and after such notice has been given as court may direct.
When the law says that you seek leave of court, that means you have to make an application. And as you make an application, you give the grounds as to why you are withdrawing your matter from court. Why it is with leave, it's because there are some conditions that may be put. There are some conditions that may be put. Because the fact that one may have filed the petition in court and served it on the other party goes out of the way to prepare, to instruct lawyers, to run around, to do ABCD. And in all, that is something that is time-consuming, and it is something that can be a cost. So now, when you apply to withdraw such a petition, the court has to listen to your grounds, and it has to see whether, yes, you are withdrawing, but what are the grounds? The grounds will inform court on what conditions that it may set for you as you withdraw your matter.
Although the law okays the withdrawal, the judiciary spokesperson Jameson Karemani asserts that court must be served formally.
We have therefore instructed our lawyers to withdraw the case from Mr. Owinyidolo's court.
We have also been learning from the press, because there is no application as we speak now about the withdrawal of the petition which has been filed.
Chagulanyi, among others, digs out the recent decision by the Supreme Court to disallow his amendments, affidavits, and failure for recusal of some members of the bench, thus anchoring his attempts to withdraw the case.
I want to remind you that the same court rejected with us what it accepted with other petitioners. So that is clearly bias.
You see, when you say the judiciary is not independent, when you are the same person who received a ruling just a few days ago, which you are using as a ground that you had been curtailed and court had to intervene and grant you an order. The same court granted you the order. These are the courts of law. So you can't say the courts of law have lost independence when they have given you a ruling a few days ago in your favor.
As to where this leaves the face and credibility of the country's judiciary, which has come a long way, this is a question I put to Jameson Karemani, the judicial spokesperson.
We have to continue set with our program as court until we receive formal communication about whatever the intentions are. Otherwise, the court sitting on Wednesday is still standing until we are notified otherwise.
The cost implications by the petitioner as he pleads for withdrawal of case now remains a one stumbling block to Robert Chagulanyi. As to whether he will comply, time will tell. Robert Onyango, UBC News, Kampala.
President.
Yes, the former presidential candidate NUP has withdrawn from the Electoral presidential elections petition, but court says they are moving on not until he informs them officially. Away from that, Minister of State for Internal Affairs Obiga Kania has refuted allegations that the Uganda police force is fused with the UPDF. During an FDC press briefing at Najanankumbi, party spokesperson John Chikonyogo said that police departments are being handled by the army, but to Obiga Kania, these institutions have different acts of parliament through which they operate.
Forum for Democratic Change Party in its Monday press briefing made conclusive remarks that Uganda police force is fused with the army to manhandle the public, including members of the opposition and the Fourth Estate by security operatives. The party's deputy spokesperson, John Chikonyogo, at the press conference alleged that while the police is supposed to keep law and order as enshrined in the Constitution and the Police Act, it has turned to the contrary, taking the front in committing brutality and violating human rights.
Most of the departments in the police are handled by the army. That's why we are not surprised to see what is happening in the country, that the police and the army use more brutal force as opposed to civil handling of civilians.
It has not been repealed. The UPDF Act is totally different, and they spell different functions for these institutions. So there's no way you can say a law-abiding government, such as the NRM government, can unilaterally fuse separate institutions without going through a due process.
Obiga Kania clarifies that in situations where the nature of internal disturbance cannot be handled by police, it is authorized to call on other agencies for help. Some of the operations where the army has reinforced police are military in nature.
Bobby Wine or Robert Kyagulanyi has never hidden his view that he is supposed to have a military situation. He has created it. He mobilizes the population to act beyond what the police sometimes can handle. So
although Chikonyogo criticized the plan by army to hand over a list of abductees to police, saying it is a wrong move, Obiga Kania said it is part of the investigations since it is a police matter to handle and take necessary actions.
Under normal circumstances, it would have been the police to investigate and decide.
So to me, I don't see any major problem there. Whether they were handled by, they were released by, investigated when they're in custody, I think that will even be improper. Let the police receive them, whether they release them on bond, whether they release them, they charge them in court.
Meanwhile, Chikonyogo advises people who have been brutalized to fight for their own rights through going to courts of law, protesting, and journalists can write about the inhuman treatment. I'm Navka Farida at Najanankumbi.
Just like the minister advised, journalists have filed a case against the Attorney General seeking to be protected against continued abuse of their rights while executing their duties. The case comes at a time when some journalists were recently assaulted by security personnel while at the United Nations Human Rights Commission offices recently.
On the 17th of February 2021, more than 5 journalists were beaten, sustained physical injuries, and their gadgets destroyed while they covered the National Interplatform President Robert Kyagulanyi Ssentamu, who had showed up to petition United Nations Human Rights Commission. On the 18th of February 2021, the Chief of Defense Forces, General David Muhoozi, came out and condemned, apologized and regretted the actions of security operatives against journalists and ordered for immediate action to be taken against individual security personnel.
2, training. 3, working out modalities of how to engage with the media. They have their obligations also. We have our own.
Even when the order was respected, journalists were still dissatisfied, alleging that the convicted were not to raid people and still demanded for real victims to be arraigned for public identification and face the long arm of the law. Journalists through their counsel, Stephen Kalali, a human rights activist, have filed a case to the Court of Appeal against the Attorney General on declarations why journalists were interfered with while doing their legal work.
For over the years, this is what the agents of the state have been doing. They beat up journalists in the course of their duty who are unarmed, who are not even demonstrating, who are clearly identified with their tag and attires on. They disregard them, beat them up in a bid to frustrate them from doing their work.
Kalali says they want justifications on the continued attacks on journalists by security organs. Kalali is also known ruling out advocating for a permanent injunction to other security agents from interfering with the work of journalists.
The request we want court to give us, one, is a declaration that all accredited journalists and the media at large have a right to practice journalism freely in Uganda without any interference. We want a permanent injunction to be issued by court against the state or Attorney General in regard to the aforementioned acts of the state agencies towards journalists so that they stop interfering with the works of journalists at large.
Kalali says apologies can't be a daily routine practice by security chiefs while leaving perpetrators of human rights atrocities at large.
And all we see and the entire situation.
This is the first time security camera manhandling journalists starring with our work. The intention of the actions remain unclear, and whose Reuters photojournalist was severely injured while covering Kyagulanyi Ssentamu in charge of unlawful firearms and ammunition. Article 29, Section 1A of the guarantees media freedom of speech and expression, include freedom of press and other. Amid this backdrop, the journalist Nasaku, UBC News.
The Uganda Law Reform Commission has simplified a number of amendments as Aikawa reports.
Uganda Law Reform Commission amended from 2016 to reference Electoral Commission, Local Government, Presidential and Funds Acts.
The National Union's Council Act, Stability Act, Labor Unions Act.
The Attorney General will cost 200.
Just that for some reason the people are not aware and the amendments were there.
Is that you're going to find a one-stop center for all the laws. This can be distributed to all the parties and also increase awareness on it. For me, I think this is good progress.
Just by level of funds, Uganda Law Reform Commission led receipt of different amendments from the different specific groups.
However, the issue of electoral reforms is going to remain a sticky issue until all the stakeholders get on the table and do something about it.
The simplified version of the laws, judges, litigants understand better the amended
law. When identify a law, that we will have an in-depth study where we consult widely with the experts in the law, as well as the users of the law, as well as the public. So the core experience is that we would go through a series of consultations and then validate these particular research findings, which would include recommendations.
The judiciary still has a shortfall of hardship across the country, and this is one thing.
Within just the commercial, because we could afford power that we have, but now with this arm of government being empowered, independence,
Uganda Law Reform to study and keep under constant review the acts and all other laws comprising the laws of Uganda. To date,